Hello students, in this video we are going to learn how to make a good dissertation. Dear students, before I tell you how to write a good dissertation, I want to tell you something deeper. Why should you write a good dissertation at all? Is it to pass an examination? To obtain a degree? To complete a formality? If that is your answer, then you will write a dissertation. But you will never write a good dissertation. A good dissertation begins not with a paper or laptop, but with a question in the mind and a restlessness in the conscience. Dear students, when we are going to make a dissertation, we have know that a degree certifies qualifications, but a good dissertation reflects awakening. The university does not expect you to merely show that you have read books, you can quote cases, you can reproduce theories. The university expects you to show that you can think independently, you can question the law, you can see injustice and ask why it exists. A good dissertation is the first proof that you are no longer only a student but a research scholar in the making. And dear students, a degree certifies qualifications, but a good dissertation reflects awakening. The university does not expect you to merely show that you have read books, you can quote cases, you can reproduce theories, but the university expects you to show that you can think independently, you can question the law, you can see injustice and ask why it exists. A good dissertation is the first proof that you are no longer only a student but a scholar in the making. Think of your dissertation as a conversation. You speak to judges, you respond to lawmakers, you agree or disagree with scholars, you question silence where the law has failed. When you write a good dissertation, you are silently saying, I respect the law, but I will not accept it uncritically. That courage to question with respect is the true beginning of legal scholarship. A poorly written dissertation may still earn marks, but it does not earn self-respect. Years later, when you look back, you will not remember how many pages you wrote, how many footnotes you used. You will remember whether you were honest with your ideas, whether you dared to think differently, whether you wrote something that truly belonged to you. A good dissertation is not for the examiner alone. It is for your future self. Many students ask to me that, Sir, what topic should I take? Then I say, take a topic that disturbs you. A good dissertation reveals what angers you in the law, what disappoints you in the system, what you wish the law could become. In this sense, your dissertation is not just academic writing. It is intellectual autobiography. Law is not neutral, and neither is your writing is neutral. Law lives in prisons. Law lives in courtrooms. Law lives in streets, homes, bodies of the marginalized. When you write a good dissertation, you acknowledge. You acknowledge that law is not only about rules, it is about human lives affected by those rules. A good dissertation refuses to be neutral where injustice exists. It chooses reasoned commitment over comfortable silence. In future, you may become a teacher, you may become a judge, you may become an advocate, a policy maker, you may become a researcher, but whatever you become, your dissertation trains you. Your dissertation trains you to think patiently. Your dissertation trains you argue responsibly. Your dissertation trains you to doubt respectfully, and your dissertation trains you to conclude honestly. A good dissertation teaches you slow thinking in a fast world, and that is a rare virtue today. When you write a dissertation, you are trusted with facts, you are trusted with sources, you are trusted with voice of others. A good dissertation respects intellectual honesty. A good dissertation respects originality, and a good dissertation respects truth. Plagiarism is not merely an academic fault, it is a moral failure of scholarship. To write well is not just a skill, it is an ethical commitment of the student, it is an ethical commitment of research scholar. And dear students, always remember this: many people cannot write, many injustices cannot speak, many realities are never documented. In this situation, your dissertation gives voice to silence. When you write about prisoners, when you write about women, when you write about workers, when you write about transgender persons, children, when you write about the poor, you are performing a great act of justice. A good dissertation is not loud, but it is lasting. Examiners read hundreds of dissertations, but most are forgotten. But some remains in memory because they ask an honest question. They offer a fresh insight. They show intellectual courage. A good dissertation tells the examiner this student did not merely complete a requirement. This student thought seriously. Many students fear the length, the complexity, the expectations, but fear disappears when you realize the dissertation is not a burden. It is an opportunity to be original, an opportunity to be sincere, an opportunity to be meaningful. So, dear students, you may write many things in life like petitions, judgments, articles, opinions, but your dissertation will always remain your first independent intellectual signature. Make it honest, make it thoughtful, make it worthy of law you serve, because a good dissertation does not end with submission. It begins a lifetime of thinking. Dear students, the LLM dissertation is not merely an academic formality. It is the first serious exercise in independent legal research. Through this work, the university evaluates whether you can move beyond textbooks and classrooms and engage with law as a living, evolving institution. A good LLM dissertation demonstrates intellectual maturity. A good LLM dissertation demonstrates research discipline, analytical depth, and ethical responsibility. In essence, it answers one fundamental question: are you ready to think like a legal scholar? Now, we have to understand what a dissertation is and what a dissertation is not. A dissertation is a systematic investigation into a legal problem conducted through recognized research methods and resulting in a reasoned and original argument. It is not a compilation of notes, judgments, or opinions. It is a coherent legal argument supported by authority and analysis. And a dissertation is not a long answer to an examination question. Dissertation is not a summary of books. A dissertation is not a collection of questions. And a dissertation is not a purely descriptive account of law. Always remember, length does not create quality, reasoning does. In this regard, in this journey, selection of topic is very important. The quality of your dissertation depends largely on the quality of your topic. A well-chosen topic provides clarity, direction, and scope of analysis. A good topic should be specific, not vague. A good topic should be researchable, not merely theoretical. A good topic should be legally significant, not trivial. A good topic should be contemporary, not absolute. And a good topic should be capable of critical examination. For example, topic like human rights in India. This is a very weak topic. And opposite of it, we can take a strong topic like judicial expansion of the right to privacy under Article 21 after Puttu Swami case. This topic is specific. This topic is researchable. This topic is legally significant. So, we have remember that dissertation topic should be always specific, researchable, and legally significant. In the selection of topic of dissertation, we can take help of sources of topics. There are many sources of topics like recent Supreme Court or High Court judgments, reports of Law Commission, constitutional amendments, social problems with legal implications, international conventions and comparative law, gaps between law and practice. A good topic usually emerges where law claims success but reality shows failure. Though there are many sources of topics, also we can take help from law journals and newspapers. In this regard, identifying the research problem is a very important step in making a dissertation. A research problem is the core concern of your dissertation. To define what exactly you wish to examine and why it matters. A good research problem identifies a gap, conflict, or inadequacy in law. A good research problem raises a question of interpretation or implementation. A good research problem has social or constitutional relevance. For example, despite progressive judicial pronouncements, marginalized communities continue to face barriers in assessing constitutional rights. In this journey, after identify the research problem, research topic, we have to create some research question. Research questions guide the entire study. They must be clear, focused, and answerable through research. For example, how has the judiciary interpreted the concerned right? What are the limitations of the current legal framework? What reforms are required? These are many examples of research question. These research questions guide the entire study. After a research question, next step is make a hypothesis. A hypothesis is a tentative proposition that the research seeks to test. Research hypothesis is a tentative presumption of the researcher. We can say that a hypothesis is a torchlight for a researcher. A researcher is work in the light of this torch. For example, we can take example of hypothesis that judicial recognition of rights has not been accompanied by effective institutional mechanisms for enforcement. This is a hypothesis. Your dissertation should ultimately confirm, modify, or reject this hypothesis. It means hypothesis could be proved or disproved. Remember, there are no any effect on your research if your hypothesis is disproved. Hypothesis can be proved or hypothesis can be disproved. In this journey, the research methodology is very important. There is a simple question. What is the research methodology? Research methodology explains how you conducted your study and why your method is appropriate. Dear students, I will explain research methodology in very simple language. Do not be afraid of this term. It sounds technical, but the idea is very basic. Suppose I ask you, how did you reach the conclusion written in your dissertation? Your answer to this question is called research methodology. In other words, research methodology is equal to your research journey explained step by step. It tells the reader what you studied. It tells the reader how you studied. It tells the reader from where you collected the materials. And it tells the reader why you used the method. An example to understand methodology in daily use example. Imagine you are a doctor and diagnosing a patient. The doctor checks symptoms, orders tests, studies reports, then given a diagnosis. If someone asked the doctor, how did you reach this diagnosis? The doctor explains the method. Similarly, in a dissertation, your conclusion is equal to diagnosis and your research process is methodology. It means research methodology means the scientific and logical way you used to study your legal problem. Research methodology explains your approach. It explains your tools, your sources. Research methodology explains your process. It is not about what you found, it is about how you found it. Many students often ask, Sir, why should we write methodology separately? Then my answer for those students that because in research, result alone are not enough. Process also matters. Research methodology shows your work is not guesswork. Research methodology shows your study is systematic. Methodology shows your conclusions are based on proper research. And methodology shows your approach is academically valid. It builds credibility. Methodology builds trust also. Think like an examiner. If you write a strong conclusion but do not explain, that where your data come from, you do not explain which cases you selected, you do not explain how you analyzed law, then the examiner will think this looks like opinion, not research. But if you explained about methodology, then methodology tells the examiner, I did not assume, I investigated. There are many types of methods. In LLM dissertation, usually these methods are used, first of all, very common in law, that is doctrinal method. This means Doctrinal method means studying statutes, reading case laws, analyzing judgments, examining legal principles. Its simple meaning is library based legal research. After the doctrinal method, there are another method, that empirical method. This means survey, interview, questionnaire, field data. Its simple meaning that ground reality research. For example, studying prison conditions by interviewing inmates is a empirical method. Another method, that comparative method. This means comparing Indian law with foreign law, studying different legal system. The simple meaning of this method, side by side legal comparison. You Why you must justify your method. Do not just write the method, also explain why you choose it. For example, if your topic is judicial interpretation of Article 21, then doctrinal method is appropriate, because you are analyzing judgments, you are studying legal reasonings, so you must write doctrinal method is used because the research focuses on statutory and judicial interpretation. It means methodology prevents random writings. Without methodology, research becomes scattered. Without methodology, writings become descriptive. Without methodology, conclusion become weak. And with methodology, research become focused. With methodology, arguments become structured. And with methodology, conclusion become reliable. Dear students, please remember this line. Methodology is not a decoration in your dissertation. It is the backbone of your research. So, when you write your methodology, ask yourself, what exactly did I study? From where did I collect material? How did I analyze it? Why is this method suitable for my topic? If you can answer this clearly, your methodology chapter is correct. Remember, a weak methodology undermines even a strong topic. Methodology ensures credibility, transparency, and academic rigor. Now I am going to explain about structure of good dissertation. There are many preliminary pages in dissertation, like title page, declaration, certificate, acknowledgement, table of content, list of cases, abbreviations. Dear students, before your main chapter begins, every dissertation starts with some preliminary pages. Many students think these pages are just formalities, but they are actually very important. Think of preliminary pages like the front portion of a court judgment file. They identify who wrote it, under whose guidance, with what authenticity, and how the reader should navigate it. First of all, we have to know about title page. This is the identity card of your dissertation. When someone picks up your dissertation, the title page is the first thing they see. It usually contains title of the dissertation, your name, course name, department, university name with logo, supervisor's name, year of submission, etc. What makes a good title page title? Your title should be clear, specific, academic, not too long, not vague. For example, we can take a bad example like human rights study. This is bad title. And we can take example of good title, that judicial expansion of right to privacy under Article 21 of the Indian Constitution. This is good title. Remember, the title should tell the reader exactly what problem you studied. After completing the title page, next is declaration. Declaration means your personal statement of honesty. Here you officially state that this work is your own. You have not copied it. It has not been submitted elsewhere. Sources are properly acknowledged. In simple words, this is your academic oath. You are telling the university, this research is my original work. Why it matters? Because plagiarism is a serious academic offense. Declaration shows academic integrity. Next one is supervisor's certificate. This is given by your research supervisor, research guide. It certifies that the student worked under their guidance. The work is satisfactory. The dissertation is fit for submission. Understand it in simple way that if declaration is your honesty statement, certificate is your guide's approval statement. It tells the examiner, yes, this student genuinely worked on this research. It is very important, always remember it, that never submit a dissertation without your supervisor's approval. After understanding about title page, about declaration and certificate, next one it is the acknowledgement. Acknowledgement is the gratitude page. Here you thank your supervisor. Here you thank your teachers. You thank your institution. You thank your library staff. And here you write about family support. But remember, this is not emotional writing. Keep it respectful, short, formal, and balanced. Don't write long emotional stories, and don't thank 25 people, 50 people. Keep it academic and dignified. Simple rule is that write about gratitude. Don't write about drama. Next one is table of content. Table of content is the roadmap of your dissertation. It tells the reader what chapters are included in your dissertation. It tells the reader about page numbers and structure of the work. It includes chapters, subheadings, conclusion, bibliography, and annexer if any needed. What is the importance of table content? This is very important because examiners first look at the table of contents to understand your structure, your logical flow, and coverage of topic. If contents are well organized, then examiner gets a good first impression about your dissertation. So table of content is very important. After the table of contents, there should be a list of cases. In legal dissertation, this is very important. You list all case law cited in your dissertation. This must be in alphabetical order with proper citation. Here it may be a question that why the list of cases needed. Dear students, law research depends heavily on judgments. This list helps the reader quickly locate case references. That's why this is very important. In preliminary pages, next and last one is list of abbreviations. In dissertation, we used many short forms like SC for Supreme Court, HC for High Court, AIR for All India Reporter, and another example like UGC for University Grant Commission, as IPC for Indian Penal Code. Instead of explaining again and again, you can create a list of abbreviation page. The purpose of this list is save spaces, avoids confusion, and improves readability. Dear students, remember this clearly. Preliminary pages are not fillers. They establish identity. They establish authenticity, structure, and credibility. A well-prepared beginning creates examiner confidence before chapter 1 even starts. After preliminary pages, now chapter 1 is started. This is introduction of dissertation. Dear students, now we will understand the most important chapter of your dissertation. This is chapter 1, introduction. Many students think introduction means just writing 2 or 3 pages of general information. That is completely wrong. Introduction is the foundation of your entire dissertation. If the foundation is weak, the whole structure becomes unstable. This chapter tells the examiner that what you are studying, why you are studying it, how you are studying it, and what your boundaries are. It sets the direction and limits of your research. Now let us understand each part in simple language. First one is background of the study. What does background mean? Background means the context of your topic. It answers why did this issue arise. It answers what is the historical or legal development of this topic. It answers why is this topic important today. We can take simple example. If your topic is right to privacy under Article 21. Your background may include evolution of Article 21. Your background may include real judgments. Your background may include the Puttu Swami case. And your background may include growing importance of digital privacy. You are not analyzing deeply here. You are only preparing the reader to understand the issue. Think of background like setting the stage before the main drama begins. After the background of the study, next step is statement of the problem. Now this is very important. After giving background, you must clearly say what exactly is the problem. You have to focus on the research problem. Many students write 10 pages but never clearly state the problem. The problem should be specific. The problem should be show a gap in law or implementation. The problem should show conflict or weakness. We can take an example like even though privacy is recognized as a fundamental right, there is still lack of clear data protection legislation. That is the problem. Without a clear problem, research becomes descriptive. Without a clear problem, argument become weak. Always remember, if there is no problem, there is no research. Very simple. That is very clear. If there is no problem, there is no research. It clear? After objective of research. Objective answer, what do you want to achieve through this study? They are your goals. They are goals of your research. And objectives should be clear. Objectives should be precise. Objectives should be realistic. There are many examples of objectives like to examine judicial interpretation of Article 21, to analyze limitations in enforcement, to suggest reforms. Remember, do not write vague objective like to study the law, to understand the issue. No, this is the wrong way. Be specific. Objectives guide your entire writing. After it, next step is research questions. Research questions are extremely important. They convert your problem into questions. If your problem is confusion in implementation, your questions may be, how has the judiciary interpreted the right? If your problem is confusion in implementation, your question may be, what challenges exist in enforcement? What reforms are necessary? These questions control your chapters, prevent unnecessary writing. It helps in forming conclusion. Think of research question as the steering wheel of your dissertation. Next one is hypothesis. Now we come to hypothesis. Hypothesis is a tentative answer to your research problem. It is not your final conclusion. It is what you assume at the beginning. For example, judicial recognition of privacy rights remains largely symbolic due to lack of implementation mechanisms. During your research, you will test this assumption at the end. You may prove it correct or modify it or reject it. Hypothesis makes your research analytical, not descriptive. In this chapter, next one is research methodology. In research methodology, you explain how you conducted research, what method you used, why it is suitable. For example, if your topic is mainly about case laws, you will use doctrinal method. And if your topic include field survey, you will use empirical method. Methodology answers how did you reach your conclusions. It shows that your work is systematic, not random. Next one is scope and limitations of your dissertation. This part defines your boundaries. Scope means what you are covering, and limitations means what you are not covering. For example, the study is limited to Indian constitutional law. It does not cover international jurisprudence in detail. Empirical data is limited to certain regions. This shows honesty and clarity. Every research has limits. Acknowledging them shows your maturity. Why chapter 1 is so important? This chapter sets the direction. This chapter defines boundaries. This chapter controls future chapters, and this chapter helps examiner understand your approach. If chapter 1 is clear, your dissertation becomes focused. If chapter 1 is clear, your argument becomes strong. If chapter 1 is clear, your conclusion becomes logical. And if chapter is confused, if chapter 1 is confused, entire dissertation becomes scattered. This is my advice, that before writing chapter 1, sit quickly and ask yourself, what exact am I researching? Why is it important? What problem am I solving? What do I want to prove or examine? If you can answer these clearly, your introduction will be strong. Always remember, chapter 1 is not just an introduction. It is the blueprint of your entire dissertation. So, make properly your blueprint. Another most important part of the chapter 1 is a review of literature. This is the another most important part of the chapter 1. A review of literature examines existing scholarly work. This examines judicial and legislative developments and research gaps. It must be critical, not descriptive. Dear students, now we will discuss about a review of literature. Let me say something very clearly at the beginning. A review of literature is not a summary chapter. It is a critical thinking chapter. You can use the term part on the place of chapter. Many students make a serious mistake here. They collect 10 books, 15 articles, 20 cases, and simply describe what each author has written. This is not a literature review. That is a book report. A good literature review shows what others have already said. A good literature review shows where they agree or disagree. A good literature review shows what is missing and where your research fits. Now let us understand each part carefully. First of all, existing scholarly work. What is the existing scholarly work? This means books, journals, articles, research papers, PhD thesis, reports of scholars, many recommendations of commissions. What should you write here? You should write what major scholar have are good. You should write what theories exist. You should write about what interpretations are given. But remember, do not write long summaries. Don't copy paragraphs. Write in your own words. Focus only on what is relevant to your topic. How to write literature review properly? Instead of writing Professor X has written a book on privacy and explained the importance of privacy in detail. No, this is not a way to write literature review. Write like this: Professor X urges the privacy for the core of human dignity and must be interpreted broadly under Article 21. However, his analysis does not sufficiently address implementation challenges. See the difference. You mention the scholar and name of his book or paper, explain their argument briefly, add your observation. That is critical writing. This is the right way to write literature review. After it, judicial and legislative developments is the next part of literature review. In law, literature review is incomplete without important case laws, without statutory changes and constitutional amendments. But remember, you are not analyzing deeply here. You are showing the development of thinking. What to include in this part? Landmark judgments, changes in interpretation, important acts related to your topic, law commission's report should be included. For example, if your topic is privacy, you may mention early restrictive interpretation like Menka Gadhi expansion, Putto Swami recognition, and data protection legislation. But do not write full case analysis here. That belongs to later chapters. In a literature review, you show how legal thinking has evolved over time. After it, now we are coming on research gaps. This is the most important part of literature review. After studying scholars and cases, you must ask what has not been studied. what is ignored, where is the weakness, what questions remain unanswered. This is called identifying the research gap. Why research gap is important? Without research gap, your topic looks unnecessary. Without research gap, your dissertation looks repetitive. Research gap shows why your research is needed. We can take example of writing research gap. Instead of writing, many scholars have written about privacy. Write like this. While extensive scholarship exists on judicial recognition of privacy, limited attention has been given to the practical challenges in enforcement mechanism. The present study attempts to bridge this gap. This is how you justify your research. How to structure a review of literature properly. Let me give you a simple method. Step 1. Group authors thematically. Do not write author by author randomly. Instead, group like this. Scholars supporting broad interpretation. Scholars criticizing judicial activism. Scholars focusing on implementations issues. This shows maturity. It means one side supporting scholars, one side criticizing scholars, and another side focusing on implementation issues. And step 2, compare views. Shows agreements, disagreements, conflicts in opinions. For example, while scholar A support expensive interpretation, scholar B warns against judicial overreach. This makes your writing analytical. Step 3, identify what is missing. After comparison, write what is missing, what is under researched, why further study is needed. That naturally leads to your dissertation. But common mistakes in literature review by students, these are writing only summaries, no critical comments, no connection between authors, no research gap identified, copy paste from articles. Always remember this. Literature review is not about showing how much you have read. It is about showing how well you have understood and evaluated what you read. After it, we have to know what should be the tone of literature review writing. Your tone should be academic. Your tone should be neutral. Your tone should be analytical and respectful. Don't criticize emotionally. Instead of writing scholar A is wrong, write scholar A's arguments appears limited in addressing practical enforcement concern. That is scholarly language. What should be the length of literature review? This is the most important question. Usually 10 to 20% of total dissertation. Not too long, not too short, balanced and focused. My final advice that when writing a review of literature, ask yourself, What have others said? Where do they agree or disagree? What is missing? How does my research add something new in academic field, in legal field, in society? If you answer these four questions clearly, your literature review will be strong. Always remember that a good literature review does not close discussion, it opens the door for your research. Dear students, now you come to the heart of your dissertation, the core analytical chapters. If introduction is the foundation and literature review is the background of study, then these chapters are the real intellectual work. This is where the examiner will see whether you can think critically, whether you can analyze law, whether you can construct arguments logically. Let us understand each part carefully and clearly. First of all, historical background of the topic. First, we study the history, but remember, this is not storytelling, it is analytical history. Why include historical background in our dissertation? Because law does not develop suddenly. Every legal concept has origin, evolutions, turning points. Understanding history helps us understand why the law exists. History helps us understand how it changed and what problems exist earlier. What should you write here in the historical background part? If your topic is related to Article 21, you may explain early narrow interpretation like A.K. Gopalan case and expansion through Menka Gandhi and later broad interpretation. And you can take another example like my subject labor law. If your topic is related to labor law, you may discuss colonial labor laws. You may discuss post independence reforms and lastly recent labor codes. But remember, focus only on relevant developments. Show evolution, highlight key turning points. Do not write unnecessary history. My important advice is that at the end of historical background, always show how history leads to the present research problem. This creates logical flow. The international perspective is the very important chapter. We can say it comparative analysis, international perspective. Now we expand our view beyond India. Law does not grow in isolation. Many legal principles develop through global influence. Why include international perspective in our dissertation? Because courts refer to foreign judgments, international conventions, influence domestic law. Comparative study shows strengths and weakness. What should you write in your dissertation regarding international perspective or comparative analysis? You may include how other countries deal with the same issue. How may other countries deal international treaties, UN conventions, comparative judicial approaches, but do not write full foreign law textbooks. Write key differences, key similarities, and important lessons. For example, if you are writing your dissertation on privacy, compare India with USA, especially Fourth Amendment approach, and UK Human Right Act approach. Then conclude what India can learn or avoid. Now, in your dissertation, the next chapter should be interpretation of statutes or legal framework in India. Now we come to the technical legal analysis. Statutory interpretation means how courts read the law, how words in statutes are understood, how provisions are applied. What should you do here? Examine relevant sections, explain important terms, analyze ambiguity, discuss legislative intent. For example, if studying the Transgender Persons Act, analyze definitions, study procedural mechanism, identify weaknesses. Do not just reproduce sections. Explain what they mean, how they work, whether they are effective. Next chapter should be analysis of case law or role of judiciary. This is extremely important in law dissertations. Case analysis means understanding facts briefly, identifying legal issues, explaining ratio decidendi, and evaluating reasoning. How to analyze properly the cases? Do not just narrate the case. Instead, step 1, what was the issue? Step 2, what did the court decide? Step 3, what reasoning was used? Step 4, do you agree or disagree? And why? Add your critical view respectfully. For example, the judgment marked a progressive expansion of constitutional rights. However, it did not clarify implementation mechanism. That is analysis. Thematic discussion. Now, this is where your dissertation becomes structured. And instead of writing randomly, divide into themes. What is themes? For example, if your topic is prison reforms, themes may be include overcrowding, health conditions, women prisoners, under trial issues. Each theme becomes a subchapter. Why thematic approach is important? This is important because it brings clarity, avoids repetitions, shows systematic thinking. Each theme must connect to your research questions and your problem statement or statement of problem. Next is comparative insights. Comparative insights means after analyzing history, statutes, cases, international law, you compare them critically. Ask what is working, what is failing, what difference exists, what reforms are possible. This is high level thinking. Logical flow should between chapters. This is very important. Each chapter must connect logically. For example of flow, history shows evolution. International perspective gives broader context. Statutory interpretation shows current framework. Case law shows judicial approach. Thematic discussion shows ground realities. Comparative insights shows evolution. There must be continuity. Do not write disconnected chapters. Golden rule for core chapters, that each chapter must answer this question: how does this chapter help in solving my research problem? If it does not help, remove it. Common mistakes by students: too much history, blind copying of foreign law, case narration without analysis, no connection between chapters, no critical opinion. Core analytical chapters are where you prove you are not just reading law, you are thinking about law. This is where your dissertation becomes scholarly, analytical, and meaningful. Always remember that in core chapters, you are not reporting law, you are examining, questioning, and evaluating it. Now you are going to discuss about discussion chapter, the intellectual center of the dissertation. Dear students, now we are entering the most important part of your dissertation. This is the discussion chapter. If introduction is the foundation, if literature review is the background, if core chapters are the analysis, then discussion is the soul of your dissertation. This is where the examiner will truly understand whether you have only collected material or whether you have understood, interpreted, and evaluated it. Let us understand each part carefully. What is a discussion chapter? Many students think discussion means repeating what they have already written. That is wrong. Discussion means explaining what your findings actually mean. It answers, so what? Why does this matter? What does this show about law and society? It is the place where your voice becomes clear. Interpretation of findings. After analyzing case law, statutes, international materials, historical developments, you must now interpret your findings. Interpretation means what pattern did you notice? What trends emerged? What contradictions appeared? For example, you may find the courts give progressive judgments, but implementations is weak. For example, you may find that courts give progressive judgments, but implementations is weak. Now, in discussion, you explain why is implementation weak. Is it administrative failure? Is it legislative gap? Is it social resistance, you move from description to meaning. Simple rule, core chapters say this is what exists, discussion says this is what it means. After it, connecting theory and practice. Law exists in books, but it also exists in society. And theory means constitutional principles, legal doctrines, and academic arguments. Practice means court functioning, administrative implementation, ground realities. Then what should you do here? Ask, does practice match theory? Ask, is constitutional promise fulfilled? Ask, is law effective in real life? For example, theory says equality before law, but practice shows marginalized communities still face barriers. Now discuss. What is the point of discuss? Why this gap exists? How serious is it? What does it show about our legal system? This connection makes your dissertation socio-legal and mature. After it, assessing the effectiveness of law. Now we move to evaluation. You must ask, is the law achieving its objective? You must ask, are judicial interpretations consistent? You must ask, is legislation clear and workable? You must ask, are enforcement mechanisms strong? Be honest and balanced. Do not say the law is completely useless. Instead say, while the legislation provides a progressive framework, practical enforcement remains limited due to institutional constraints. This shows academic maturity. How to evaluate properly? When assessing effectiveness, consider clarity of provisions, consider judicial consistency, administrative implementation, accessibility to citizen. Support your points with reasoning and avoid emotional languages. Highlighting socio-legal implications. This is where your dissertation connects to a real society. Law is not just rules, it affects people. Socio-legal implications mean how law impact individuals, whether justice reaches marginalized groups, whether social inequality affects enforcement. What should you write? Ask, who benefits from this law? Ask, who is excluded? And ask, does it promote social justice? Does it widen inequality? For example, if studying prison reforms, how do overcrowded prisons affect human dignity? Are women prisoners treated differently? Are under trial prisoners suffering due to delay? Here you show sensitivity and critical thinking. There are many important differences. Let me clarify something important. Analysis chapter, you examine legal materials, and in discussion chapter you interpret, evaluate and connect. This is where you show intellectual independence, confidence and scholarly maturity. How to structure the discussion chapter? A simple method: brief restatement of key findings, interpretation of patterns and trends, gap between law and practice, evaluation of effectiveness, socio-legal implications, link to research questions. There are common mistakes in discussion chapter, that is repeating earlier chapters, writing summary instead of interpretation, no critical thinking, emotional criticism, no connection to research problem. My advice that before writing discussion, ask yourself, what did I actually discover? Ask yourself, what is surprising? Ask yourself, what is problematic? And ask yourself, what does this show about the legal system? If you answer these clearly, your discussion will be strong. Why discussion chapter is called intellectual center? Because here you stop reporting and you start thinking. You stop describing and you start evaluating. This is where you prove you are not just a student of law, you are becoming a legal scholar. Remember that the discussion chapter transforms information into understanding and understanding into insights. Dear students, now we come to the final chapter of your dissertation. This is conclusion and suggestions. Let me tell you something very clearly. The conclusion is not the end of your dissertation. It is the final proof of your intellectual journey. This is the chapter where the examiner will ask, did the student actually answer the research problem? Was the hypothesis tested properly? Are the findings clear? Are the suggestions practical and thoughtful? If your conclusion is weak, the entire dissertation looks incomplete. Let us understand each part carefully. First of all, answering the research questions. In chapter 1, you framed research questions. Now in conclusion, you must clearly answer them. Do not introduce new arguments. Do not bring new cases. Simply answer, what did you discover? What is the final position? What is your reasoned conclusion? For example, if your research question was, how effective is judicial protection of privacy rights? Your conclusion must clearly say, judicial protection is progressive in principle. However, enforcement mechanisms remain weak. Implementation gap reduces effectiveness. It should be clear, direct, and structured. Remember, if your research questions remain unanswered, your dissertation remains incomplete. And second, testing the hypothesis. After answering the research question, you should testing the hypothesis. In the introduction, you made an assumption, that is your hypothesis. Now you must Test it honestly. Ask, was my assumption correct? Ask, was it partially correct? Was it wrong? Be honest. Do not force your research to fit your hypothesis. For example, if your hypothesis was judicial recognition remains symbolic, after research you may conclude it is partially symbolic, it is progressive in interpretation, but implementation is weak. Then write the clearly. This shows maturity and academic integrity. Next is summarizing key findings. Now you summarize what you discovered, but remember, do not copy paragraphs from earlier chapters. Do not repeat long explanations. Instead, summarize in clear, structured form. You may use subheadings or numbered points. For example, key findings is judicial interpretation has expanded fundamental rights. Next, legislative support is inadequate. Next, administrative enforcement remains weak. And last, socio-economic barriers affect implementation. It should be short, clear, and analytical. Next, proposing legal and policy reform. Now comes the most important part. This is suggestions. This is where you show creativity and responsibility. Your suggestions must be practical, logical, legally possible, and it should be based on your findings. There are many types of suggestions like legislative reform, judicial clarification, administrative improvement, institutional mechanism, policy restructuring. For example, instead of writing government should improve the law, write like this: amend section 10 to clarify enforcement procedure. Establish independent monitoring authority. Create time-bound implementation mechanism. Be specific. Remember, suggestions must arise naturally from your findings. Suggesting areas for future research. Dear students, no research is perfect and no dissertation answers everything. So, you must mention what remains unexplored, what needs deeper empirical study, what comparative research can be done. For example, you can write like this: further empirical study on regional implementation, comparative analysis with European data protection framework, study on judicial training mechanism. This shows intellectual humility and academic awareness. And one very important thing is that what you should not do in conclusion. That is, do not introduce new arguments. Do not add new case analysis. Do not write emotional statements. And do not make unrealistic suggestions. Next, structure of a good conclusion chapter. You may structure it like that: brief introduction, next answer to research questions and testing of hypothesis, summary of findings, recommendations, future research, This should be logical and systematic. Why conclusion is so important? Because this is the chapter where your research journey comes together. This is the chapter where your arguments are finalized, and this is the chapter where your intellectual identity becomes visible. If introduction was the blueprint, conclusion is the final structure standing complete. My advice that before submitting your dissertation, read your conclusion carefully and ask, have I clearly answered my research problem? Are my findings visible? Are my suggestions realistic? Does this chapter show maturity? If yes, your dissertation is strong. Dear students, always remember that a good conclusion does not merely end the dissertation. It leaves the reader convinced. One more thing is very important: the writing style and academic discipline. Language and expression should be formal and precise, objective and reasoned, free from emotional or journalist tone. And paragraph structure should be, each paragraph should introduce an idea, explain it with reasoning, and support it with authority, and conclude clearly. Dear students, a good LLM dissertation is not written to impress the examiner alone. It is written to train your mind, discipline your thoughts, and shape your scholarly identity. Law progresses when students question it seriously and responsibly. Write your dissertation with sincerity, patience, intellectual courage, and respect for truth, because long after marks are forgotten, your dissertation will remain a record of how you learned to think as a liar. Wish you all the best for your dissertation. Thank you.